Brilliant. Thank you for your patience. Okay, so jumping right into clause 9. Come on, computer. So where did we end off, basically? It was a couple of months ago. I ended off with the defects and return of the deposit, which gets a bit complicated. But if there's no questions, then there's no questions. Also, if you just read through it a couple of times, it's not rocket science, but it is a process in respect of the pre-inspection needs to be done not by us, technically, according to the lease. And we prefer to stay out of it unless we're doing rental management. And then you've got the post-inspection. You've got the post-inspection should be done as well. And then if the inspections are not done by one party, then there are implications, okay? And in respect of the return of deposit, either needs to be done 7 days after the lease or 14 days after the lease, depending on criteria being whether there are damages that need to be attended to. Okay, this is an easy one, so we're going to run through it pretty quickly. I'd actually like to finish the lease today, so I think what I'll do is, Mark Wilson, excellent, Marky. What I'll do is I'll jump over certain clauses that are really self-explanatory, but you're welcome to slow me down a little bit. Just be in touch. Let's make it interactive so I've got some time to breathe. All right, this is a critical clause. The lessor, one second. The lessor warrants that as at the commencement date, the premises must be in good working order and condition. Okay, I know I paraphrased that, but that's essentially what the landlord needs to have in mind. And more particularly, that all the installations, okay, I'm not going to read it word for word, all the installations and the systems and the appliances, everything's working, okay? If you can bring it to their attention and not just expect that the landlord and the tenant has read every clause and will follow every clause, in a perfect world, you know, that would be great. But to avoid issues, either on the second day of the lease or down the line, I recommend just advising them of these kind of the highlights that I'm sort of bringing up now, all right? The premises must be clean and comfortably habitable. If they're not, you can put the tenant, with our advice, if the tenant asks, the tenant can put the landlord in breach if the place is not comfortably habitable, all right? Any instruction manuals need to be there. Yeah, right, like that's ever around. Okay, and all the systems need to be, what it says, in respect of instruction manuals for systems and everything and fittings and appliances, in case the lessee doesn't know how to read that, all right, how to operate those. All charges in respect of levies, municipals and rates, taxes, mortgage bonds and all that must be paid up in full and not be in arrears prior to the occupation date. We added that after a few situations, as you can imagine, came up and electricity was being, cut off. And, you know, it came back to us that first you should have checked before you even listed the property, or you should have warned me as the tenant that there might be issues that will arise, such as cutting off water and electricity, because a landlord has been in arrears, and the tenant would say, I wouldn't have moved in. Okay, and the lessor shall present upon request any of these statements to the lessee or first. The lessor will keep the structure. So think structure, don't think small things, okay? We're talking walls, we're talking roofs, flooring, you know, in case, you know, flooring can give way, that kind of thing, of the premises, and the roof in state of good repair, but will not be liable to the lessee for any loss or damage, whether direct or consequential of whatever nature or cause, except for instances resulting from the grossly negligent or intentional conduct of the lessor. You certainly watched my videos, and you're also going to see this maybe just 2 or 3 times further in the lease, but it's more come up previously, where we have protected the tenant by way of adding to the lease that if the landlord has been grossly negligent or through their intentional conduct has done something to the premises that has now affected the lessee's comfortable, is the word habituation of the lease, then the landlord can and should be held responsible. And through clauses like this, which I don't see in other leases agreement, I'm very proud of these clauses, we we ensure that the lease is fair on both sides. Okay. By the way, we have had tons, probably 10 times more issues with landlords than tenants over the years. Quickly, yeah, go for it.
Yeah, no, I was just going to ask, what would qualify as grossly negligent?
Excellent. So what do we mean by grossly negligent? Great question. So let's say the landlord doesn't pay their levies and their rates, which they obviously know about. They're grossly negligent. It's obvious they know they have to pay it. And 3,000 rands worth of frozen food goes sour in the fridge because of electricity that's been cut off or water that's been cut off for a week. That's grossly negligent. Okay. It could be intentional conduct. If there's fighting between the two parties, then it can be argued, no, Mr. Landlord, this was intentional conduct of yours. You actually cut it off in order to upset me and that kind of thing. All right.
What the landlords tend to take advantage of to avoid, suffering consequences, if that makes sense. What does the avoid accountability on that?
Let's talk about that afterwards. Could be. I'd need to think of examples. Okay, but it's not particular on this clause, and I'm happy with questions, but I'd like to move on. Notwithstanding anything to the contrary contained in this lease, should the lessor fail to comply with the lessor's the landlord's obligations in terms hereof, or should repairs be necessary as a result of fair wear and tear? Remember, if there's fair wear and tear, the landlord is obligated to repair that. And fair wear and tear or load shedding, or should major repairs be necessary, the lessee will be entitled to deliver to the landlord written notice demanding that the landlord effect the necessary repairs to the premises within 7 days. And in cases of emergency, the notice period will be 12 hours. You can imagine how we've added to this clause over the years as there's been urgent situations that landlords haven't attended to timeously. In which case the premises will be promptly repaired by the landlord in the event of the landlord failing to respond to the notice or failing to attend to the repair within a reasonable time. The lessee will have the right to effect these repairs. The lessee will have the right to effect these repairs at a reasonable cost and to claim a reimbursement of the cost from the landlord, which will be payable on demand. Sorry, Ian, I cannot hear you. Oh, I wonder if it's my speakers. Sorry, Ian, 1 second. It might not be your microphone. Hold on 1 second. I need to plug something in and then I'll be able to hear you. Oh, shucks.
It's from my side.
I didn't swear, I said shucks. I don't swear. Yeah. Okay, Ian, talk to me.
Can you hear me now? Can you hear me now? It's showing that my audio is going through, but you're not
Ian,
responding.
when you're ready for your question, either shout or just text me, okay?
Okay. Can anyone else on the meeting hear me?
Did you hear something? Oh, no.
No,
I can hear you.
Okay, let's move on.
Sorry, somebody else can hear me.
Right, we're up to lessee's obligations. Subject to the terms of this lease, the lessee will be responsible for the care and maintenance of the premises. We've had tenants leave hundreds of thousands of rands, okay, maybe up to 100,000 rand worth of damage to gardens specifically. And these are great tenants. They're nice people. They pay on time, but they overlook these things. And this is why it's important that landlords actually come and visit the premises with reasonable notice to tenants, and they inspect the premises a couple of times during the year, specifically if there's a beautiful garden. During the duration of this lease and at the termination date, will deliver the premises to the landlord in the same good order and condition as at the commencement date. Fair wear and tear, however, is accepted. So if the tenant received the pool green, the tenant can give back a green pool, all right, technically. Notwithstanding the above general clause, the lessee specifically undertakes to, and where applicable, keep and maintain gutters, sewage pipes, water pipes, and everything free from blockage. This is easy stuff. And remember, obviously, this is only for full title properties. clean the carpets and other floor coverings regularly. I think you can read through this at your own time. Maintain and keep in proper working order all hinges, locks, electrical connections, taps, other fixtures, fittings, furnishings. So these are the small things, right? If the tenant breaks the key, that they should go and have a new key found. If a light bulb goes out during the lease agreement, it's the tenant's obligation to actually go and purchase another light bulb. Sometimes these things get a bit sticky. Don't know how clear this really is in the Rental Housing Act, but generally speaking, that seems to be the norm. The smaller things that even say if roaches or ants come and flood become a problem during the lease agreement, it's for the tenant it's for the tenant's account to call out pest control and pay for that. Again, we do have situations where the tenant says, no, it shouldn't be my problem. But if you run into issues where clients are calling you and there's a bit of a disagreement and you're not too sure, give me a shout, and usually we can advise and we can bring some light to the matter. Okay, the lessee needs to provide at the lessee's own expense. Okay, there it is, all types of light bulbs. At the lessee's expense, keep and maintain the grounds, the lawns of the premises in a neat and tidy condition, etc. The lessee will not commit or permit the cutting down, removal, or destroying of any trees or shrubs without the prior written consent of the lessor. Those things are considered fixtures, okay? The lessee must maintain a swimming pool. The lessee may in no way interfere, 9.4.7, no way interfere with the electrical appliances. So these are installations or wiring on the premises, and any damage by short circuit or any other manner arising out of such interference will immediately be made good by the lessee. Okay, you can read through the rest of this. 9.4.8, the lessee shall make good and repair at the lessee's own cost any damage or breakages by reason of any furniture or other objects or vehicles being brought onto or removed from the premises or otherwise, as and when they become necessary, unless such damage or breakage results from the grossly negligent or intentional conduct of the landlord, or unless the repairs are necessitated by reasonable wear and tear. If I'm going too fast, or if you want me to explain something, I'll do the best I can. Please text, or please put it in the chat, or stop me. The lessee, or shout out, the lessee shall be obliged to repair any of the above mentioned items that become damaged or degraded as a result of their actions, the lessee's actions, right? Within a reasonable time frame which shall be determined by the lessor. My favorite example here is a pool that the lessee hasn't maintained properly. Algae apparently, I'm no pool expert, the algae apparently starts to grow on the sides of the walls. This lands up affecting the pool pump, and within 3 months you can have a pool pump that goes belly up. That can cost a fortune. Who's to say that the lessee will actually land up paying for it? The lessee can disappear overnight. It can be a major headache, and that's why things need to be fixed within a reasonable time frame. All right. The lessor or its representative shall, at the lessor's sole discretion, be entitled to make good and repair any damages or breakages caused by the lessee and to recover the actual reasonable costs of doing so from the lessee, unless such damage or breakage results from their negligent or intentional conduct. So that's in a situation where, where the tenant, for example, has damaged the pool pump, but isn't, and the landlord happens to be aware of it, and the tenant is not interested in repairing it. Landlord can go and have it repaired. Okay, hopefully in this case, the landlord will give access to the premises, right? If the premises form part of a sectional title scheme or homeowners association, the lessee will not be obliged or entitled to maintain the exterior of the premises or the amenities insofar as the obligation or right to do so is imposed on or vests in the relevant governing body. In the event of the landlord deciding to sell the premises during the period of this lease, the lessee agrees, and that's any time during the period of the lease. The lessee must agree to allow prospective purchasers to view the premises at all reasonable hours with reasonable notification. And this is really important if you haven't heard it. If you haven't heard this phrase, huur gaat voor koop, which means the lease takes precedence over a sale, and this always applies. So The property can be sold 5 times during a lessee's occupation of the premises, but the lessee's lease agreement remains intact. They got nothing to worry about, all right? In the event of in fact, the truth is that the lease does not even need to be re-signed with the new owner. It transfers automatically. Of course, what does need to happen is the deposit plus interest needs to be transferred to the new owner. In the event of the landlord deciding to re-let the premises, and you can read the rest, it's pretty straightforward, all right? And obvious. Insurance. If the property is freehold, the lessor will arrange a normal house owner, and we obligate the landlord to do this. Sometimes it gets a bit sticky, obviously to protect the tenants' movables if there are breakages and things, if there is damage from rain and these kinds of things. The landlord will arrange a normal house owner's comprehensive insurance policy on the premises. The lessee will insure and keep insured the movable contents of the premises in respect of all risks covered by the normal house holders comprehensive insurance policy, save for those movables insured in terms of clause 15.4 below. Speak to your local insurance guy if you're not familiar with that. I have a bit of knowledge around this. If it becomes an issue, speak to me. The lessee will not use or permit the use of any apparatus. So think of gas and these kinds of things, right? Or permit the carrying on of any trade or process, or permit the keeping of any combustibles, etc., which may impair or affect the lessor's right to claim in terms of the insurance policy, or have any other adverse effect on that policy, or to do something which will lead to the increase of any premiums. Just looking if there are chats. Here is a chat. From Ian, jump to latest. Just trying to scroll to that. I'm having issues with my mic. Can you not hear me? Okay, Ian, yeah, we've discussed that. So, improvements and additions, very important, okay? The lessee shall, throughout the currency, I think that's the right word, of this lease, be responsible for notifying the landlord in writing of any damages to the premises caused by any rain, hail, lightning, and the like, any structural defects, leaks, damp, water intrusion, burst water pipes or geysers, electrical faults, or any other defects for which the lessor is responsible. This could include, for example, branches from a tree falling onto electric fences, right? For which the lessor is responsible, as soon as these become evident, to enable the landlord to claim from its insurer, if applicable, and to avoid any consequential damages to the premises. The lessee will not make any alterations, additions, or improvements referred to below as modifications to the premises, or to any installations at the premises, whether structural or otherwise, or drive or permit any. So even something as small as a nail or a screw to be driven into the walls, ceilings, floors, or into any furniture or fittings thereon, or allow anything to be done that may damage the walls or any other portion of the premises without the landlord's prior written consent, which will not be unreasonably withheld. It's interesting. So what does this mean? The landlord may not unreasonably withhold the tenant's right to, for example, put up a couple of pictures, all right? Maybe install a washing line on the back of the premises if it's a 2-acre property and there's no washing line and nobody's going to see it, this kind of thing. And which consent will be reduced to writing in an addendum and be signed by both parties. Can we run? Yeah. Good? Cool. Should the landlord grant that written consent, the landlord and the lessee will in the written addendum agree on whether or not and the extent to which the lessee will be entitled to remove those modifications. So either the landlord will say, you can install it, but you must remove it. If it's a couple of nails, you can install it, but either it's okay. So the landlord can say, you're welcome to keep, you don't need to remove those nails when you leave the property, or if you wish to drive those nails into the wall, for example, or install that washing line, you need to make good after the lease, meaning take out the nails, plaster, repaint. Okay. That's can be said at the landlord's, can be decided at the landlord's discretion. Now, so important, in the absence of a written signed addendum referred to above, any modifications made by the lessee will, upon termination or cancellation of this lease, at the landlord's discretion and option, either be removed by the lessee. The lessee must remove it, in which event any damage or defects resulting will be repaired by the lessee at the lessee's own expense. And so again, you have to read it like this. Back to 11.4 in order to read B. So you go, in the absence of a written signed addendum referred to in clause 11.2, any modifications made by the lessee will, upon termination or cancellation of this lease, at the landlord's option, either remain, in which event, or that must remain, in which, so the landlord chooses for that to remain, in which event all such modifications will become the property of the landlord. And that can be a large television bracket, for example. The landlord can say, you are not going to remove that. You didn't ask for permission. And if you pull this out, heck, half the wall is going to come down. This thing is now my possession. And the lessee will be deemed to have waived any claims of whatever nature arising out of such modifications, and the lessor will not be required to compensate the lessee in any manner in respect thereof. Should the lessee fail to comply with the demand made by the landlord in terms of above, the lessor will be entitled, in addition to any other remedy or right available to the landlord in terms of this lease, to have the relevant modifications removed and to recover such costs from the lessee, including the cost of repairing all damage and or defects caused by such removal. Okay, no more chats. Occupation, quite interesting. Notwithstanding any receipt given for any rental or deposit paid in terms of this lease, the lessee will have no claim for damages or other rights of action against the landlord if the landlord is unable for any reason whatsoever. I know this doesn't seem so fair, but clients accept it, so we choose to keep it in. It protects the landlord. For any reason whatsoever, to give the lessee occupation of the premises on the commencement date, unless attributable to gross negligence, okay, so this protects the tenant, or intentional conduct on the part of the landlord. In such an event, the lessee will be entitled to a remission of rental for the period of non-occupation. Okay, so look, I suppose we get away with having any reason, for any reason whatsoever. Could be a big whirlwind, what do you call them? A tornado comes through, properties half damaged, not suitable for occupation. That can be, it's an example in this case. And so the landlord cannot be held responsible for that. But if the tenant is not able to take occupation, obviously there has to be what's the word? A remittance, a rental paid back, a refund of rental. Okay, the lessee may not, okay, no, let's leave it there. The lessee may not. Okay, just one example. If the premises cannot be occupied, say, for 2 months because there's such damage, I would say that a landlord would need to be reasonable and actually allow the tenant to break the lease agreement, to cancel the lease agreement and go find another property. Okay, not just to go stay at a guest house for 2 months and still hold them to the lease agreement. They can leave and go, they can break the lease agreement and find new premises. The lessee may not, without the landlord's prior written consent, which cannot be unreasonably withheld, allow the premises to remain unoccupied for any period exceeding 3 weeks. This is pretty much for security reasons, or permit or allow any persons other than those persons mentioned above in 6.1 to permanently occupy or permanently reside in the premises. Administration fee, we charge 1,375 inclusive of that to the tenant. Prohibition against subletting and passing with possession. The lessee will not, without, funny enough, we've almost never had problems with this. And it's probably because we put quality tenants into our premises, all right? Into landlord's premises. The lessee will, so the lessee may not sublet the premises or any portion of the premises, or part with possession of the premises. They may not part with possession. I think I must change this word. There's some wording. They may not part with possession of the premises or any portion of the premises. Not sure about the grammar there. Right, furnished premises, straightforward, usually not applicable. Remember that if properties are furnished, I think I was telling Donnie the other day, somebody, for furnished it was Angela, whoever. For furnished premises, you can generally add about 4,000 Rand if it's a medium-sized apartment, say up to about 20,000 Rand. If it's furnished, the landlord's talking to you, well, if I furnish it nicely, how much extra can I get? That's usually the amount. If it's a 50,000 Rand property, it would be at least 5, maybe 10,000 Rand if the premises are fully furnished. More than that, I haven't seen, but if you're talking 80,000 Rand, might be as much as 15,000 Rand extra per month if the premises are furnished. Right, the parties record that the premises are furnished by the landlord and are let as such. The lessor, not the agent, the tenant mustn't go and count the number of knives and forks. The lessor shall furnish the lessee with a comprehensive inventory list of all the furnishing in the premises at the time of signing the lease, and this shall be annexed to the lease as Annexure B. The lessee will, within 14 days of moving into the premises, sign and deliver the inventory list to the landlord or first, notifying anything defective or missing. Excuse me, failing which the items in the inventory will be deemed to have been handed over in good order and condition. This is all very logical. Might be new to you, but it's very logical. The lessee will maintain and repair the items where necessary under instructions from the landlord. On the termination of the lease, the lessee agrees to return the items on the inventory to the landlord in like condition, but fair wear and tear is accepted or accepted. Any damages to the items, however, any damages will be made good by the lessee. This whole business of fair wear and tear, you can think about it like this, because I do. If the landlord was living in the premises, would the carpets have become slightly soiled, slightly dirty? Would the wall maybe need a repaint, this kind of thing? If that's the case, it's considered fair wear and tear, and the tenant is not responsible for fixing for those costs. Okay. Yep, just happens, yeah. The lessor will be personally liable to ensure the items in the inventory, and the lessee agrees not to do anything that may impair or affect the lessor's right to claim in terms of the insurance policy. Okay. First and lessor indemnity, have a read through it. It protects us and the landlord under virtually all conditions, which is just safer. It's just safer. We managed to squeeze that in, and we choose to be protected under all circumstances, and we choose to have the landlord protected as well, which we just feel is fair. Otherwise, tenants, clients can potentially take advantage, and we prefer to sleep at night knowing that clients cannot take advantage of us, all right? Because they likely will if they might if that's not in there. Moving right along, breach, hugely critical. In the event of a party breaching the terms of this lease agreement and therefore failing and thereafter failing to remedy its breach, this is the process, folks. We have landlords saying, if the tenant doesn't pay on the 2nd of the month, I'm going to cancel the lease. Can't do that, all right? You've got to put the other party in breach. And this is the process. Within 7 days after receipt of written notice from the other party calling upon him to rectify such breach, the other party shall be entitled to claim damages from the defaulting party in terms of this agreement, and this includes either party's right to bring the claim before an applicable court. Furthermore, should the defaulting party fail to remedy its breach within 20 business days after receipt of written notice, the other party shall be entitled to cancel this agreement, notwithstanding any steps already taken in terms of the other party's enforcement of his rights in terms of this agreement. So just to go back, I do get confused with this because there's 7 days and there's 20 days. So again, in the event of a party breaching the terms of this lease agreement and failing to remedy its breach within 7 days after receipt of written notice from the other party, calling upon them to rectify such breach, then the other party shall be entitled to claim damages, etc. But furthermore, should the defaulting party fail to remedy its breach within 20 business days after receipt of such written notice, so I think as it goes, if I recall, so the other party can claim damages within 7 days, but the lease cannot be cancelled until 20 days, until the other party is in breach for 20 days. I think that's how it rolls. Notwithstanding any steps already taken in terms of the other party, right, I think we said that. The defaulting party undertakes to pay on demand to the aggrieved party all expenses, costs, and charges arising out of the breach by the defaulting party, including tracing agents, cost, collection commission, all legal costs and scales between attorney and client, whether in respect of court, arbitration, rental, housing tribunal, or other proceedings. That's general legal terminology. Okay, I'm not going to scroll up so quickly in case you're a little bit behind. Should this agreement be cancelled by the landlord as a result of any breach or breaches by the lessee and the lessees, failure to remedy such breach or breaches, the lessee and any other person occupying the premises hereby undertake to and shall immediately vacate the premises. Should the 17.3, should the lessor cancel this agreement and the lessee dispute the right to cancel and remain in occupation of the premises, then the lessee shall, pending the determination of the dispute, continue to pay all amounts due in terms of this agreement on the due date, and the lessor shall be entitled to accept such payments without prejudice to the landlord's claim for cancellation of this agreement. Upon the determination of this dispute, the payments made in terms of this clause shall be deemed to be amounts paid by the lessee on account of the holding over. So I think basically what that means is rental paid by the tenant during this breach clause must go towards the rental and not other costs that the landlord has accrued. Okay. If the Consumer Protection Act is applicable to this agreement, it is recorded that the lessee is entitled to cancel this agreement upon providing to the lessor 20 business days written notice of his intention to cancel this agreement. In the event of this occurrence, the lessee shall be liable, however, to the lessor for a reasonable cancellation penalty. There's no free ride. Lessee can cancel if the lease agreement falls under the CPA, the CPA, but there is a cancellation penalty. That cancellation penalty, folks, this is important, is not stipulated in law anywhere. It's not 1,000 Rand, it's not 100,000 Rand. It's a reasonable cancellation penalty, okay? So therefore we add, at least to give the parties some guidance in respect of how much that's going to be. The parties hereby agree that the penalty payable by the lessee to the lessor shall not be less than 1 month's rental, plus the agent's commission already charged to the landlord for the remaining months of this agreement that were not realized. Let's just go back a step in terms of the CPA. Basically, you can regard, it might not be this straightforward in all circumstances, but in respect of a tenant leasing agreement leasing from a legal entity, okay, as far as the name on the lease is concerned, or a landlord who is renting out their property as an investment on an ongoing basis. If that's the case and the lessee is renting out this lease agreement in their personal capacity, then leases, in those cases, leases then fall under the CPA. Okay. In all other cases, they usually don't. Okay. T's and C's apply. In the event, 17.4.3, in the event of 17.4.1 above occurring, the lessor undertakes to take all steps necessary to place a new lessee as soon as possible. What does that mean? That once the lease has been cancelled by the tenant, the landlord must duly and timelessly try and find a replacement tenant. They cannot sit back and have the premises not occupied for 6 months and then say, you owe me 6 months of rental because post you leaving, I haven't been unable to rent out the premises, okay? Because they may have a claim. If they cannot rent out the premises and the landlord can prove that they've tried to, there can be a claim for that period of time that the landlord wasn't able to re-rent the premises. Should a warrant of attachment for the premises be served on the premises during the currency of this lease, that would be because the owner hasn't paid their bond, hasn't paid levies, hasn't paid rates and taxes. Okay, that's how warrant of attachments come about. Then this will constitute, obviously, a breach of this lease by the landlord, which, if not rectified, will entitle the lessee to cancel this lease. Should the lessee breach any of the terms of this lease on more than 2 occasions in any consecutive 12-month period, the lessee shall be entitled to cancel this agreement forthwith, without further notice. So the landlord doesn't need to continually put the lessee in breach if the lessee is in breach. On the third breach, obviously assuming that the lessee rectified the breach in the first 2 examples, right? That's why the lease continued. So on the third breach, the landlord doesn't need to put the tenant in breach again. They can cancel this lease agreement forthwith without further notice and claim possession of the property, take back the property, notwithstanding any previous waiver or anything to the contrary in this lease agreement contained. This right is exercised without prejudice to the landlord's claim for any arrear rental and any other sums payable hereunder, and for any damages which it may suffer by reason of such breach or cancellation. Okay. This is all legal mumbo jumbo, as you'll find in pretty much any contract, any legal contract that's signed. Have a read through that. No clients ever change this because it's standard stuff. Right, seriously important. Not that it comes about very often, but it needs to be in every sort of lease agreement. Partial total destruction. Thank God we do live in a country with tons of problems, but one of the problems that we don't have is natural events on a grand scale. In the event of the premises being destroyed or significantly damaged, and the lessor and lessee agreeing in writing that beneficial occupation is no longer possible, this lease will terminate unless the parties agree otherwise in writing. So what we've done is we've said to the clients here, listen, you guys have to sort it out. We're not going to come and help you guys agree that the premises are still fit for habitation, that this needs to be fixed. You guys really deal with it yourselves, okay? In the event that the premises are destroyed or damaged as contemplated above as a result of the lessee's negligent or intentional conduct. So the lessee is careless with a 20-kilogram gas bottle, half the premises explode, that's where 19.2 comes in. The lessor will be entitled to recover any damages suffered. Okay. Ooh, our favorite clause, agency commission. Now, why did I add this in about 2 weeks ago? Because any amendments need to be initialed by first or of no force or effect. Because from time to time, we have landlords that chop and change things in this paragraph, and they immediately think that first has to agree to it. They were obliged to agree to these changes. No, unless we initial, consider it as a discussion, as a negotiation. By their signatures on this lease, 20.1, the parties acknowledge and agree that we are the effective cause of the introduction of the lessee to the lessor. In the instance that the lessor sells the premises to the lessee will be liable for a sales commission. Time is going slowly, only 45 minutes in. And we've covered so much ground. The below applicable commission will be earned and payable, and the lessor will pay first such commission upon signature of this lease, or any renewals or on the date of any renewals or extensions of this lease by the lessor. So what is our commission? Dot number 1. For a 12-month lease agreement, a sum equivalent to 1 month's rent plus VAT. Has anybody worked out what percentage that is? That works out to? It's 8.3 recurring percent, but it is the industry standard. Although I know it sounds hard, but it's the industry standard, and it's 1 divided by 12. 1 month's rental divided by 12. That's how you get to that. Smaller operators do charge less, but we probably give better service, and we're a bigger player in the market, and so generally speaking, in most cases, we, so to speak, get away with our standard commission. But always look at the big picture. If you've got a client that it has given you multiple other properties, or if the property is over 25, 30,000 Rand, be negotiable. if the client is putting pressure on you. Okay, that's what I recommend anyway. But don't just give in to the client's first demand. You know, client says 6% plus VAT, non-negotiable. That's all I'll accept. Don't come in and say, okay, try find some middle ground. Okay, in other words, have some pride and negotiate effectively. For a lease agreement of, and please also remember, and I say this with the greatest amount of respect and humility, but First's commission, our company commission, is also affected as you negotiate the commission. So it's not only you. So we should also have a say in it as you may negotiate the commission. For a lease agreement of more or less than 12 months, a sum equivalent to 8.3% plus VAT of the gross rental payable for the full lease period will be charged, and that's payable annually. So if you only do an 8-month lease, then the commission is prorated, okay? Which is why we never suggest a lease agreement less than 12 months. First will, if necessary, be entitled to receive payment of the commission directly as the first charge against rental paid if actual occupation never takes place. So the lease is cancelled for any reason. Then, and that's prior to occupation, first will, if necessary, at its sole discretion, be entitled to recover the commission from the defaulting parties. Okay, you can dream up some examples there. Things happen. Okay, for example, maybe client gets relocated through work. Lease is cancelled. We are still entitled to commission, folks. Still entitled, okay? In that case, we can go after the tenant. We've done our work. We're entitled to commission. Thank you very much. If the landlord changes their mind, whatever scenario comes about, children coming back from overseas, I've seen it all. Client wants their property back. Nobody's going to hold a gun to the landlord's head to say, you need to continue with the lease agreement. But we need to tell the landlord, we don't actually, because it's in the lease agreement, we are entitled to commission, Mr. Landlord. And not only that, the tenant might sue the pants off you. So we recommend re-evaluating your decision. If actual occupation, is that what I just said? Yeah, I think. 20.6, in the event of this lease being cancelled as a result of the actions of either party, the parties will not have any claim against First for a refund of the commission or a pro rata portion thereof. I absolutely love this clause, because what does it really say? If the parties aren't getting along, or there's any dispute whatsoever, fair wear and tear, damages, whatever, whether it's 5 days into the lease or 11 months and 10 days into the lease or 6 months into the lease, our commission remains sacrosanct. It cannot be touched. It cannot be retrieved, okay? It remains ours under all circumstances. Their business is their business, right? Companies, closed corporations, and trusts. The signatory warrants that a separate ancillary deed of surety, don't ask me what that is, shall be signed immediately upon request by the landlord. Okay, so I think what that is if I recall, it's a surety addendum that needs to be signed if the landlord requests to this agreement. Say if it's a small company and the income of the company doesn't reflect very well in the bank statements, landlord can say, Mr. Director or Mr. Director's grandmother, I insist that you sign surety for the lease agreement. Okay. If the lessee is or is acting on behalf of a company, CC, or a trust, or is a representative for another legal entity, and has the crux of the matter, that is yet to be formed. Then, so this hardly happens, okay? Then the signatory to the lease will, so the human being, remember that legal entities don't sign lease agreements, they can't. A human being, the signatory, that's not the person who signs surety, that's the signatory to the lease agreement, will be personally liable as the lessee under this lease if the entity to be formed is not formed within 30 days of acceptance of the lease by the landlord, or the entity does not adopt or ratify this lease and provide a copy of the signed resolution to First within 30 days of acceptance of the lease by the landlord. And or the lessee is a trust and the signatory does not provide a copy of the trust deed and letters of authority to first on the signature of this lease by the lessee. In those cases, then the signatory themselves can be held personally liable without any further addendums or annexes to this lease agreement. Okay, so that I know probably quite confusing. Don't worry, never comes up. The lessee, this reads on. So last thing, the lessee will be personally liable if the lessee is a trust and the signatory. Didn't I just say that? I think I did. Non-variation clauses. Again, this is very standard mumbo jumbo, but let's read through it quickly. This lease constitutes the entire agreement between the parties. And first, but remember, we are only, and you must remember to use this terminology, we're not a party to the lease, we are a facilitator to the lease. There is a very big difference, okay? As wide as the San Andreas Fault. And no representations by either of the parties or first or their agents, whether made prior to or subsequent to the signing of this lease, will be binding upon either of the parties and upon first, unless in writing and signed by both parties and first. Okay? If we don't say it later on, let me just repeat that because I think that said it. So if there are any changes, yeah, basically, if that seems a bit mumbo jumbo, if either party wants to change anything or add to anything in this lease agreement post signing, it needs to be signed as an addendum in the lease agreement, to the lease agreement. Remember, an annexure is a document that is attached to the lease at the time of signing. Addendum, as opposed to annexure, is a signed document at any time that can be signed at any time post the lease agreement signing, and it must refer to this lease agreement. I'm happy to help with wording if the parties need, and that must be then be attached to the lease. Okay. No variation, alteration, or consensual cancellation of this lease or any of its terms will be of any force or effect unless, I'm sorry, here it is. I haven't read through this in a couple of years, to be honest. Unless in writing and signed by the parties and first. So now you've heard it twice. No waiver or abandonment by either party or first of any of its rights in terms of this lease will be binding on that party and upon first, unless such waiver or abandonment is in writing and signed by the waiving party. And that's not this kind of waiving. General, the parties and first consent to the jurisdiction of the magistrate's court. Okay. Have a read through it. Standard stuff. 23.2, in the event of a dispute as to the interpretation of any of the clauses in this lease, alternatively, a dispute between the parties, either party may appoint an independent person to assist the parties resolve the dispute. And it might be advisable that they agree on one person to help, like a neutral person, right? In the event that the lessee is a foreigner, the lessee warrants that the lessee has the relevant residence permit valid for the duration of this lease period, entitling him or her to reside in South Africa, but we must receive that. Don't take anybody's word for it, and we should do our homework and ensure that we have noticed that they are a foreigner, and we need to see that residence permit. In the event of the landlord selling the premises, the landlord will cede and assign all the rights and obligations of this lease to the new owner. The lessor will notify the lessee and first of the intended change of ownership in writing. Should there be more than one lessee, the lessees, this is very important, especially when it comes to, okay, well, in all situations, husbands and wives, or a couple of friends, or two professional colleagues renting the lease agreement. Let me use professional words there, being lessees on the lease agreement. Remember, and you would have seen this in my videos, you have occupants of the lease in the premises, and you have lessees. Lessees or lessors are those people that have signed the lease, okay? Excuse me, how rude. Just text me. Actually, I left my phone not on silent in case anybody needed to call to tell me about issues that we may have with connection. How's that for an excuse? Right. So the lessees bind themselves jointly and severally, the one paying the other to be absolved for their obligations in terms of this lease. What does this mean? Husband and wife, they get divorced. The one leaves the country or leaves the city or thinks that they are no longer, and they both sign the lease. The one thinks that the one thinks that he's left the premises, say, is not in occupation of the premises. They think that they are no longer obligated to pay for the lease, to pay their way. They are still obligated. However, sorry, I just remembered. What this is really saying is that even that each lessee individually is responsible for the entire amount. Of course, the lessee or the landlord can sue every lessee who has signed the premises, but the lessee, the husband, mustn't say to the landlord, no, I'm only entitled to pay you 50% of the cost of the rental, okay? Did I explain that well? Let me know if I didn't. First is an accountable institution in terms of the regulations governing the FICA Act, or the FIC Act of 2001. The validity of this lease shall not in any way be affected by the transfer of the premises. We touched on that a few minutes ago, if I recall, from the lessor pursuant to a sale thereof. It shall accordingly, upon registration of transfer of the premises into the name of the purchaser, remain in full force and effect, save, and we touched on this in respect of the huurgeld voor koop, remain of full force and effect, save, except that the purchaser shall be substituted as lessor and acquire all the rights and be liable to fulfill all the obligations which the lessor, as lessor, enjoyed against or was liable to fulfill in favor of the lessee in terms of this lease, except, save, for the right to renew the lease in terms of clause 4.1, 2.5, which right shall lapse and be of no further force or effect should the lease not already have been renewed. In other words, the new purchaser does not have to accept any renewal of this lease should the tenant want it. 23.8, the parties consent in terms of POPI to the collecting, storing, and processing of their personal information, etc. The parties, 23.9, agree that their personal information may be shared with the other necessary role players necessary to give effect to this agreement, including but not limited to the agents, internal staff, etc. Okay? 23.10, the agency shall retain the party's personal information for only as long as is necessary, that's I think 5 years, and in compliance with PAPAIA and with any legislation such as FICA and the State Agency Affairs Act. So remember, or you perhaps don't know, that from time to time, what are they called? The regulators, which were from the State Agency Affairs Board, now known as the property, what are they now called? The professional, what are they called? Anyway, can't recall what the PPRA, of course, people.
Yeah, the property
Whatever that
practitioners
stands for.
regulation.
Okay, so regulators from the PPRA do surprise us from time to time, and they say, show us old records that you are storing of lease agreements, of sale agreements, and show us that it is under lock and key. If it's paper under lock and key, if it's stored electronically, it must be behind a password. The parties have the right to object to the collection, processing, and or retention of personal information, and have the right to request that personal information be corrected or deleted, or to lodge a complaint with the information regulator. By the way, if the rental housing tribunal, if its name ever comes up, it's somewhat worthwhile for the parties to go to the rental housing tribunal, but you can tell them that they don't have ultimate power, and that if the client is really serious about their case, go straight to attorneys. It is agreed between the parties. Oh, looks like Angela hasn't been with us for a while. It is agreed between the parties that the obligations of first, really important clause, will terminate once this lease has been signed by the parties, and that there will be no obligation or duty upon first either to ensure that any payments to be made by the lessee under this lease are in fact made to the landlord, or to resolve any disputes that may arise between the landlord and the lessee, or to have to take any action, in other words, to help out in any way, or do anything resultant upon the obligations and duties either of the landlord or the tenant in terms of this lease, should the lessee require that certain repairs or maintenance or alterations be effected by the landlord to the premises, the lessee shall communicate directly with the landlord in regard thereto. What does that say? Our official obligations post-signing, post-occupation are over. Any further involvement that we choose to get involved in is up to our discretion, okay? And I can promise you now, in 19 years, I see it all the time. When we give a hand to help, the client just keeps on pulling. It's really scary. So be prepared that when you get involved, either know your limit, have a limit, or know that you're just going to get dragged in and dragged under. Consent clause. Okay, you can have a read through that. This is essentially saying that we are entitled, if I recall, we're entitled to do another credit check on the client should the landlord request it. Okay, and we can furnish information concerning this 24B concerning the behavior profile, payment patterns, etc., or creditworthiness of the lessee to any registered credit bureau or to any credit or service provider. Seeking a trade reference, that may seek a trade reference regarding the lessee's dealings with the landlord. Woohoo! Authority. Each person signing this lease warrants that he or she or it has the necessary authority to sign this lease, and that, where applicable, sorry, Rufina, where applicable, that they have complied with the terms of the Matrimonial Property Act. Wait a second, here it is, acknowledgement. What did that say? Authority, right. This is a great clause. The parties acknowledge, of course, the Matrimonial Act, very important, right? So know who has to sign. In fact, and I don't think it's changed, this is really important. I don't believe that one needs to go ahead and ensure that the necessary parties, and we're talking husbands and wives, have or need to sign the lease agreement. In other words, you know, when it comes to a sale, one needs to see whether the parties are married in community of property or whatever, tribal law, whatever that might be. When community of property, what's it called, or what's the opposite of in community of property? I forget now. So when it comes to a lease agreement, either party can sign, regardless of how they are married. I believe that is still the case. Quite interesting. Quite interesting, yeah. It could come about, the situation could come about, but it would probably be an internal dispute in regards to the marriage, where a husband goes and rents a property without the wife's knowledge. That could come about. Again, I don't believe that would be a problem, as opposed to a situation where a husband has gone and tried to purchase a property without the wife's consent. Although I think that's allowed if the husband in this case has gone and purchased for cash. I think the husband could then get away with it because the banks at least wouldn't inquire about how they are married. And closing off, acknowledgement. Tell that person to WhatsApp me. I'm much better with WhatsApps and phone calls. The parties acknowledge by signing this lease that they have read and understood this lease and agreed to be bound by the contents of this lease, and that the agent has adequately explained the full meaning and consequences of this lease to them before signing this lease. So even if you haven't adequately explained it, they must sign. By them signing the lease, both parties, they agree to the fact that they consent, that they acknowledge that they have understood the entire lease and that it's been explained to them adequately. All right. So if there's one or two tenants or lessees or lessors, they need to sign next to each other over there. we accept the benefits and the sessions. What does that mean? The benefits is the commission and the sessions are the risks. Okay, and then please state your name over there. The property practitioner and your manager will go ahead and must go ahead and sign as checked by full status PPRE. Is actually not necessarily a manager, but if you're a candidate, you need to be not necessarily working with a full status agent, but when it comes to signing agreements, you're not allowed to sign by yourself. But things are easy in the rental space because agreements are usually signed electronically. So that takes care of that, as opposed to in sales transactions, you usually meeting in the boardroom or around dining room tables. Okay, this is pretty self-explanatory. Let's just read the first line over here in respect of pre-inspections and post-inspections. I think I need to change that. Anyway, this form is because this is used for post-inspections as well. This form is to be completed by the landlord and the lessee prior to or within 3 days after the occupation date. It is advisable that photographs are taken and shared with all parties, including us, with pleasure, as evidence of the condition of the property. You can see how that rocks and rolls. And remember, again, this is not for you to do, but the parties must do it. And then in each block over here, the client must state the location, which wall, where it is, and how the wall looks at the commencement date. Actually just changed this up very, very much recently. I changed it up more for our property management department, where I've got different columns of, I think I should actually do that here, where the clients can sign they sign off the condition of the premises, pre-inspection, in other words, at the commencement date, and post-inspection. This doesn't really allow for a post-inspection to take place. Haven't heard any complaints so far, so maybe I won't change it. And on behalf of the clients anyway, and then lessor to repair the following items. What's meant over here, what's the implication, is that everything above is really just, and this is seriously important, folks, it is, and I haven't made that very clear here, but it is clear in the lease agreement in clause 8.1 or 8.2, I think it is, 8.2, where it talks about the condition of the premises, and that must be disclosed in writing. So everything you see here, all the description of the defects, this does not obligate the landlord to fix any of those things. It's just to note the defects, okay? But this little paragraph over here notes what the landlord actually does need to repair. And this cannot be done necessarily on the occupation date, because if it's a nice big house, there's lots, and there might be numerous appliances, machinery, or many walls and ceilings to go and walk around and have a look. And even if the person does, they might miss something. But within 3 days, the tenant does need to submit what they might find either as defective or that needs to be repaired, and then have this signed off. Okay, a key and remote inventory is over there, signed off by the tenant and the landlord. What a mouthful. Hope you enjoyed that. Any questions whatsoever, people? Otherwise, we're going to wrap up. I'll give you a minute to think of any questions. See what Ian says over here. I'm sure I made changes before you arrived. Please, can you send the latest final agreement document as many changes were made during your video? Some changes were made during my video, and some more suggested changes were referenced today. Okay, Ian, I'll tell you what, whatever changes I refer to are not, is the word consequential whatsoever, minor things. So if I don't do it, please know that every word is pretty much still applicable and won't affect, it was really minor. It won't affect any party if I don't change it, okay? Anything else, people?
All good here. Thank you so much.
Ish, hi. I'm not sure if I can hear you. And all the machines are on. So I guess you have something to say. Won't you type it, Kish? Okay, great. All right, great. Thank you for your attention and your time. Always good to see blank screens. That was cheeky. Prefer to see faces next time, but totally okay that we've done the Zoom. It really makes a lot of sense. Certainly don't mind that as well. Thanks to Donnie for coming in, and appreciate your time, everybody. I have recorded this, so if you want to have another watch either tomorrow or in a year from now, just let me know. Best of luck, and remember, I'm always quickest to get hold of via WhatsApp, but always welcome to call, and I am always available 24/6 if you have any queries. What was that chat from Ian? Please, can you fix audio your side? We could hear each other. Not too sure. I'll have a look.
I will
No
on
problem.
my side
It's usually
watch
good, but
the
yeah,
recording.
I'm sure
I
you're
don't
aware
think
of
you can hear us.
the joys of technology. Thanks, everybody.
Watch.
Have a lekker day, and all the best to you.